Hi and welcome. This is Ross Wright, the Executive Director here at Hope and Home, and I want to welcome you to Core 2, which is the legal process in adoption. And I'm going to apologize at the very beginning of this presentation for the following reason. This is one of the toughest classes you're going to take, and on some level, maybe the most discouraging class that you're going to take. And I apologize for it up front, but I also want you to know that it's a very important class. The number one reason that foster parents quit being foster parents is because they become discouraged and they feel like the expectations they had going into foster care weren't being met. In other words, unrealistic expectations are the number one cause of foster parents quitting foster care in a negative way. As a result, we want to be blunt and really direct about what is the legal process. The legal process is the number one thing that confuses foster parents and sets them up for unrealistic expectations. So we're going to go through this video and we're going to do it in 6 parts. The very first part is about the legal process itself. The second process is about the roles and responsibilities of all of the people in the legal system. The third part is about something that's called intervening, how a foster parent can become a part of the case. The fourth part that we're going to go through is what's called 30-day notices. This is very important. The fourth part we're going to go through is 30-day notices. The fifth piece that we're going to go through is the steps of the legal process leading towards adoption. And finally, the sixth part is going to be on adoption. And the structure of this video goes as follows. I'm going to talk for about 20 minutes, and then I'm going to ask you to pause the video and talk amongst yourselves. There'll be some questions on the screen. Discuss those questions among yourselves. If you're in a class, that's going to be easy. If you're all by yourself at home watching this video, you obviously can't discuss it with anyone, but it's something to meditate on, think about, and come up with some answers to the questions that show up on the screen. Then turn the screen back on, or turn it off, pause, and get it moving again, and we'll go to the next section. Okay? So let's get started. The first part we're going to be talking about is the legal standing of being a foster parent. Now, I want you to take a moment and imagine. Imagine that you have had a very difficult night. You went out, for whatever reason, you celebrated maybe a little bit too hard, you had a little bit too much to drink, you crashed your car, and you got arrested for a DUI. Well, we know all kinds of terrible things happen at that point. They tow your car away, they throw you in jail, and you have to go in front of a judge. You get released, and you get all kinds of things that happen to you. But what about your car? Well, your car gets impounded in a tow lot, and so you got to go get your car back. Well, how do you do that? Well, somebody in the system hands you a piece of paper and explains where your car is, usually directions to the tow lot, and the things you have to have in your hand to get your car back, okay? So what are the things that you have to have? Well, you have to have a driver's license. You have to have some form of photo ID. You also have to have a certain amount of money, and for whatever reason, those dollars seem to get higher and higher. I think it's $500 or $700 you have to have now. The next thing that you have to have is you got to have some sort of registration proving that it's your car. If you have those 3 things, you get your car back, right? Okay. Now, I want you to take that analogy and apply it to the child welfare world. Okay, I want you to imagine the same type of thing happens when a child is removed from care. They don't get put into a lot, they don't get put into a tow lot, they get put into your home. Now, it's obviously different. We're not talking about children as if they are cars, but the comparison works. So let's go back to the car lot. The car's in the lot. You as a parent show up. You're embarrassed. You want your car back. And you're a little upset probably that your car got towed. You're a little worried about your car. You're worried, did they scratch it up? Did they take something out of it? So you come in there a little bit embarrassed, but probably a whole lot mad and frustrated. And you're probably frustrated too that you're being seen in a certain way that you feel doesn't really fit who you are. You're being cast into the role of the drunken, irresponsible car owner. And maybe this is the one time this happened and you think it's a fluke. So you're kind of frustrated. Now, when you arrive, the people that have your car, well, They might love your car. They might think your car is awesome. They might have spent the last week looking at how amazing your car is and kind of thinking, what a jerk would wreck this car? What a jerk would neglect this car? And they'd look at all the things that have kind of happened to this car over the years. It's got scratches and bumps. And they're like, God, this person never really took very good care of this car at all. And they've allowed this to happen to it. And they might think to themselves, if I had this car, I would have taken much better care of the car. And, if I had this car, I wouldn't have wrecked it. If I had this car, I wouldn't have gotten into this accident. And, I really should be the one that has this car. But what we know is the rules of law in the United States say the tow truck operator can't keep your car. What has to happen? What has to happen is if you show up with your driver's license, with the right amount of money, with your registration, you get your car back. End of story. The fact that they love your car doesn't matter. The fact that they bonded with your car doesn't matter. The fact that they would take better care of the car than you would doesn't matter. You get your car back. Now let's take that exact example over to the child welfare world. Instead of having a piece of paper that tells you what you need to do to get your car back, biological families get what's called an FSP, and that's a family service plan. And on the FSP are a number of things that they have to do, that they have agreed to do, and their lawyer has blessed it, and the county attorney has blessed it, and now they're moving forward in what's called a stipulated agreement. A stipulated agreement is something that they present to the court, and they say to the court, we're going to move forward, and we're in agreement about this stipulated agreement, and we're in agreement that if we do these things, if the family does these things, they get their child back. Just like if you do the things on the piece of paper, you get your car back, and nothing can stop it. A family is given an FSP, which is a stipulated agreement, which is approved by both the family's attorney and the county attorney, and it has to be what's called measurable and objective. You can't put on there, be a better parent. You have to put on there, attend parenting classes and achieve a grade of a B plus or better. And you have to have it clear as a bell, because otherwise we'll get to the end of the year period of time. Most of these cases take a year, and the child has to return home, or there has to be a reason why they didn't return home within that year. Now, if it's a child under 5 years old, they fall into what's called Expedited Permanency Planning Guidelines, EPP guidelines, and that year becomes even more strict. But for all kids entering foster care, there was an act called ASFA, and I realize I'm throwing a lot of initials at you. ASFA is the Adoption and Safe Families Act of 1997, and it said kids can't languish in foster care. They have to move through the system fairly quickly so that they can achieve permanency and not always be in limbo. Now, that's a challenging thing for courts to do, and so courts have to be aggressive. They have to make sure what's called reasonable efforts are being made for this to happen. And the first thing that is done in the very first hearing is that the parents have the right to an attorney. They have the right to go to trial if they want. Most of them don't. Most of them do what's called a stipulated agreement, which means we're going to agree that you're going to suspend for a few minutes your case against us and give us a chance to get our kid back. And then we're going to create an agreement, and that agreement's called the FSP, which again is the stipulated agreement. The family service plan has a list of things that the family has to do to get their car back. Now, instead of saying you have to have a insurance form or your driver's license and your registration and money, what do they have to do? The family service plan is typically things like stable employment, stable housing. If it's a woman who has been in a domestic violent relationship with someone, that they have to go through domestic violence training. Oftentimes there is a restraining order. They have to stay away from that. If they're using substances, then they have to go through substance abuse training and treatment, and they have to have a certain number of clean UAs. Those are the typical things on an FSP. And again, they have to be measurable and objective. Now, the challenge is, how do we, even though we have the rule, even though we have the guideline of measurable and objective, how do we quantify that? How do we measure that? Let's say, for example, the family moves into a brand new house in Rockrimmon that's valued at $500,000 and has 4 bedrooms. Is that stable housing? Of course it is. Well, how about if it's a single mom with her child and they move into her parents' house and have their own bedroom? Yeah, that's stable housing. How about the living room of a boyfriend? Well, in third world countries, that would be amazing housing. So, is it stable housing? Well, it depends. One child, two children, five children? Those are the kinds of questions that get asked. Let's talk about a UA. You have a urine analysis and you have to have a year of clean UAs. Um, what if you have 11 months out of 12 of clean UAs, and on the 12th month you have a dirty UA? Or let's say in the 12th month you miss your UA. And the guidelines are a missed UA is the same as a dirty UA because oftentimes people miss them when they know they're going to be dirty. And so, what if they have a perfectly good excuse? Is a judge going to keep a child from reuniting with their parent over one missed UA when they have a good excuse? These are the questions, and these are the reason we have. This is the reason we have judges, because they have to make these decisions. What I can tell you is, as your case goes on, most foster parents find themselves falling in love with the children in their home, which they should, but being challenged by, how do I think about these kinds of things? I had one of my favorite foster parents early on say, Ross, I don't know how to pray. And he said, because I can't sit there and pray for my child's biological mother to fail her drug tests. What kind of person would pray for that, for failure of someone, and that someone would lose their child? He said, so I can't do that. He said, so what I've learned is I just have to kind of stay away from the case and not get involved in it and just pray that God's will be done in the best place for this kid to go. Because he says, if I end up with this child and I have the rest of this child's life knowing that I prayed that his mother would fail, I can't live with that. So he said, I just have to stay out of that and pray that God's will be done and let the legal system do what it does. I will say that that is a wise way of approaching the legal system. If you stay involved, if you pay too much attention, and go up and down with every single thing that happens, it will drive you nuts. Because the FSP is a guideline, and the judge can relax it or he can be strict with it. And sometimes the judge will even be aggressive with the biological mom and say something to her like, if you fail one more, you're not going to keep your child. Well, that is a way of putting pressure on the mom. It's not a deal being made with you. So I've heard parents go home and say, oh, good, if one more failure, I get to keep this child. Then there's another failure, and they're furious. Well, the judge didn't do what he said he was going to do. Again, the judge was using that as motivation. It was not a commitment that the judge was making to you. Now, what are the rights of the foster parent in this situation? A lot of people think about their rights in the same way that they think about a divorce court. There's a mom and there's a dad, and they're fighting over this kid, and they both want this kid, and they're both parents. You got to get that out of your head. Okay, that's not how it works. There was a psychologist who coined the phrase Gestalt, and Gestalt means the tendency of the brain to seek commonality in patterns. And you've seen some of these experiments that they show you, or some of these kind of examples that they show. Perhaps it's letters that are half written and put together in a sentence, and you can still read the word because your mind fills in the blanks. Or dots that almost create a picture, your mind fills in the blanks. Another example of this is a Rorschach test, an ink blot test, where it's just a random ink blot, but you seek patterns in that. You seek commonality, things that you've experienced. That concept of Gestalt is very helpful for our mind. It helps us put pieces of things together. It can also be very dangerous because we seek what we have already learned. We seek the common ground that we have with experiences in our past. So, for example, we go into family law and we go into a DNN case, which stands for dependency and neglect, which all of our cases are. They're all DNN cases. And we look for things that we've seen before, like mom versus dad. And so you think, well, if I'm a better parent, they're going to place the kid with me. Of course not. I had one of the top judges of the state of Colorado in my office, and he said, Ross, I look out into my courtroom and I see these amazing foster parents. And in my heart, I know this kid would be blessed to be with that family forever. And sometimes it tears at me that I have to return this child to a home that I know is substandard. But that's the law. And we have to understand that this is different than divorce court. It's not one parent versus the other, and it's not about the best interest of the child. It's about what is the law. And the law says that the best interest for the child, if possible, is the family that they came from. So they're always going to they're going to seek to put the child back in the family they came from. And that is critical for us to understand. What are the rights of the parents, the biological parents? Well, they still have all of their parental rights. Most people don't realize this. When a child is removed, the county takes temporary custody. They do not terminate parental rights. The biological parents maintain all of their rights throughout the entire case until parental rights, or if parental rights are removed. So let's go back to our car example. How does that fit with the car example? Well, the people that have your car at the tow shop, can they paint the car? Of course not. Can they put new seat covers on the car? Of course not. It's still your car. They have custody of it. So what do they have custody of? What are the responsibilities they have as custody? Well, as the custodians of it, they have to do what's reasonable and prudent. They have to keep the car safe. They have to keep the car covered. If it starts to leak, they better move the car. They have to be responsible with the car. But can they paint it? Of course not. Can they add new tires to it? Of course not. It's not their car. The same thing is true of us. Throughout the course of care, when a child is in your home, they're not your child. And we have to always remember we're taking care of somebody else's child. And until the time comes that the parental rights are terminated, we don't have that ability. We don't have the ability to cut hair. We don't have the ability to have the child be circumcised. We don't have the ability to have any medical procedures done because it's not our child. Does that mean that we can't provide for the child? Of course not. In the same way as the people who have the car in their lot have to make sure the car is safe and make sure the car is taken care of, we have the same responsibilities with the kid in our home. So it's important for us to know that our legal rights are extremely limited. When I say ours, I mean Hope and Homes and the foster parent. We're taking care of someone else's kid. Now, remember when I talked about in 1997 we passed the Adoption Safe Families Act, ASFA. One of the things that was created at that time was what's called concurrent care. See, prior to that time, we had foster parents and we had adoptive parents. And the foster parents would take a kid in, and in taking that kid in, they would take care of that kid, and they would never adopt that child. And that was great. It was great for the foster parents because they never got their expectations up. It was great for the biological parents because they never got jealous or worried that this person was going to take their child. And it was great for the adoptive parents because they only stepped in when the child was legally free and available for adoption. But it was terrible for the child because the child went into foster care with somebody, they bonded to that someone, they got connected to that someone, and 4 years later they had to move. So they began the process that we now call concurrent care, which means we place a child into your home and you are plan B or plan C. Plan A is always return to the parent. Plan B is go to some sort of relative or kin or friend. And after that has been exhausted, then adoption by a foster parent. So that's, like I said, not plan A, B, or C, usually plan D or E. And that's called concurrent care. Now, under concurrent care, the foster parent has the hard job. We fixed it now for the kid, but now it's really hard for the foster parent. And this is the toughest thing that you will ever do. And I say this over and over again, and I mean it every time I say it. You have to take a child into your home, fall in love with that child, be willing to adopt that child, and at the same time be willing to return that child back to their biological family or relative or friend at a moment's notice. This is the hardest part about foster care. This is why you need a good agency to work with. This is why you need a strong support system. Welcome back. This is section 2 of Core 2, and we're going to be talking about the roles and responsibilities of the different players on the treatment team of a child in foster care. Now, we learned in our last section that a child comes into care when there's an abuse or neglect, and that child is then given an attorney and has an FSP, a Family Service Plan. Well, how does that Family Service Plan get put into motion? The main person that makes that happen and works with the biological family is the caseworker. The caseworker is an agent of the county, and their number one job is to work with that child, support that family, and reunify them. That is their number one job, is to support the family and the child. And they have a casework supervisor that helps them do that. They're an agent of the county, and they have a series, and we'll learn more about this down the road here. They have a series of legal appointments they have to go to, and they also have a number of things they have to do. They have to do what's called a diligent search. They have to look for every possible relative or friend of the biological family that they can place the child with. If they don't find someone, they have to provide what are called reasonable efforts. Or in the Indian child welfare world, if we have an Indian child placed with you, they have to provide active efforts, which are even more aggressive than reasonable efforts. And they're asked about this at every single status hearing by the judge. The judge will ask them every 60 days, are reasonable efforts being provided to this family to make sure that the child has a reasonable chance of going home? This is critical, and we'll talk more about it. Reasonable efforts are critical, and sometimes parents will wonder, why is this caseworker going out of her way to do everything she can to help this family get this child back? Boy, it just seems crazy, doesn't it? The family isn't making it to meetings, so the caseworker says, well, I'll get you a bus pass, and they're still not making it. Well, I'll get you taxi vouchers. They're still not making it. So the caseworker says, I'll go and pick you up and take you to these meetings. And the foster parents sometimes feel like, why is this family being given so many chances? Why is this family getting all of these opportunities when it's so obvious that they don't want to do this? The answer is because the caseworker is required to provide reasonable or active efforts to get the child home. The second person that is in the case is the respondent attorney. Every single parent has to have an attorney. They have to be represented in court. Now, this is critical because when we think about a courtroom, every single person in that courtroom is a court officer. We don't just let anyone walk into the room and talk to the judge. There have to be officers of the court, and those are attorneys, and they have to represent individuals. So who represents the biological family? The respondent attorney. So they have a respondent attorney that defends them, protects them, is in their corner. All right? And sometimes foster parents feel like that person's a bad person. How come when I go to court, that person will attack me maybe, or say things about the family that we don't believe are true? It's their job. They're the respondent attorney. Their job is to aggressively, actively, aggressively advocate for their client. That's their job. The third person in the system is the GAL. That's the guardian ad litem. And what that means is the person who is the attorney for the child, looking out for the best interest of the child. Now, sometimes foster parents bond with the GAL, become friends with the GAL, get to know the GAL, and it's always a good idea to treat all of these folks like customers. It's always a good idea to welcome them into your home, to be open and working with them because they're very important to the case. They have a very strong opinion. So it's a good idea to be receptive and supportive and helpful to the GAL. However, the GAL is the child's attorney, not yours. And I've had a number of families say to me, the GAL told me to go get my own attorney. I think I should, don't you? Well, did they tell you to go get your own attorney, or did they basically say to you, I can't be your attorney, and if you want this information, go get your own? And that's what they're saying, because by law, the GAL cannot give you legal advice because the GAL is not your attorney. The GAL is the child's attorney. And I've had a number of foster parents get really frustrated because they thought the GAL was, quotes, on their side, and then felt like that GAL flipped sides and betrayed them down the road. You won't have that feeling if you understand up front that the GAL is never on your side. By law, they're on the child's side. Now, the child's side may correlate with your side, but not always. And that may flip and that may change. If it flips and changes, you're going to feel very much betrayed or let down, and you got to fight that because they're not your attorney. Their job is not to advocate for you. The third person on the case is the OCA, and that's the Office of the County Attorney. I think I said third. Fourth person on the case. We have the caseworker, the respondent attorney, the GAL. The fourth one is the Office of the County Attorney, or OCA. They represent the county. Through contract, they represent us. Through contract, they represent you. Okay, let's go over that again. The county has an attorney, and that is the person that was involved with the judge in the initial immediate removal of the child. The judge has to give that order in the beginning. People oftentimes think that the DHS does all this stuff on their own. The DHS removes kids. The DHS makes all these decisions. It's not the case. They have to run everything by a judge. In order to remove a child, a judge has to be involved. Who works with the judge? The Office of the County Attorney. So that's the fourth person on this case. We have the caseworker, respondent attorney, GAL, Office of the County Attorney. The county attorney represents the county. We are subcontracted workers for the county. You are subcontracted by us. Therefore, the OCA is who represents you in the courtroom. So we have those four. Now we have more. We have the therapist. There's usually a therapist for every kid. And there's a CASA. A CASA is a court-appointed special advocate. This is a volunteer, and CASAs were created back in the days when we didn't always have GALs. Judges wanted someone that was specifically there for the kid. So now we have two people whose job is to specifically be a voice and to speak up for the child, the GAL and the CASA. This is important to remember. They advocate for the child. You're a foster parent. Your job is not to be the CASA or the GAL. Your job is not advocacy. Your job is a service provider to take care of the child while all of these other people do their job. Who else is on the case? Birth families. The birth family is at every meeting. They're engaged, they're active, they're part of the treatment team. So the birth family, when you go to your first team decision-making meeting, a TDM, these will be the people that are in that room. There'll be the caseworker, usually the casework supervisor, the respondent attorney, the GAL, the therapist for the child, the CASA, the birth parents, and of course, you. Now, foster parents, what is the role of the foster parents? It's really important to know what the role isn't. You're not the caseworker. You're not the respondent attorney. You're not the GAL. You're not the therapist. You're not the judge. You're not the CASA. And you're not the birth parents. And sometimes that can be confusing because, let's go back to what I talked about in Gestalt theory, we tend to do things that fit patterns of our previous life. In our previous lives as regular parents, what have we been? We've been all those things. We've been the person that manages the case of our children. We've been the person that advocates for our kids. We've been the person who's kind of the therapist of our children. We've had all those responsibilities. So it's normal as a foster parent to feel like I should do those things. It's critical that you don't. You're the foster parent. Your job is to take care of this child and make sure all their needs are getting met and do all the things that you're required to do. On your very first placement, your home supervisor is going to come to your home and they're going to bring a binder about this thick. And it has all kinds of pieces of paper in it. And each one of those pieces of paper is important. They're optometry exams, doctor exams, dental exams. Our job as the foster parents is to make sure all of these things get done for these kids. And of course, they're kept in a safe and loving home. That's our job. It's also our job to stay out of the way of the respondent attorney, the GAL, the therapist, the judge, the CASA, all of these folks. So our job is to take care of the kids. Our job is to make sure they're safe. Our job is to love on them and give them the home that we have always wanted to give them, okay, that we've always dreamed of giving these kids. Give them those things, but don't make the mistake of drifting off into some of the other jobs, okay? Now, when you go to a TDM, all of these people will be around the room. And I can't say this loudly enough. You're the only one that's new to that room. Okay? You walk in that room, other than the biological parents, everybody else knows each other. And they're going to look at you and they're going to say, who's that person? Who's that new foster parent? And there'll be a buzz amongst the professionals wondering who's new in the room. It's important when you show up to TDMs, if you go to court, that you dress well and that you're prepared and you wear your Hope at Home name tag. Hope at Home has a very strong brand, and that brings something with it when you walk into the room and carry that brand. Now, they're going to talk about you when they're done. So be thoughtful about how you behave in that meeting. If they see you as someone who's gracious and easy to work with, friendly to the birth family, shaking hands with the respondent attorney, being friendly to everybody there and open and transparent and willing to help, that's going to be a very powerful message to each one of them. If you're hoping to adopt, that's your first opportunity to meet the professionals who will make the decision whether that child should be adopted by you. And we all know you don't get a second chance to make a first impression. So when you show up to those first meetings, you want to do it well, and you want to look again gracious, friendly, not over eager, and don't talk too much, but answer every question you can as honestly as you can and as transparently as you can. We have foster parents at Hope and Home. Tony Smedley hasn't been doing this for 7 years. People still call and say, is Tony available? Jill Lewis, foster care extraordinaire. She has done such a good job of befriending all of those people in the case that I still get phone calls from people saying, is Jill available? Because I have a child I want to place with Jill. So be very, very thoughtful about how you work with the treatment team. Now, I'm going to give you a warning about that as well. Don't forget their roles. The respondent attorney, you want to be respectful and kind, but that is the biological parent attorney. And we all know there's a rule within the legal system, and that is if you can argue the facts, argue the facts. If the facts are on your side, argue them. If the law is on your side, argue it. If neither the facts nor the law is on your side, attack the prosecution. It's an old famous legal saying. Well, the same thing applies in foster care. If you are the respondent attorney and you can't make your case for your client and you can't argue the facts because the facts are bad, you can't argue the law is against you, then you have to attack the system, and sometimes the foster care is part of the system. So it's not unusual for a respondent attorney to attack the foster family and say, yes, my mom didn't do good, but these guys are even worse. They do this and this and this and this. So when you're working with the respondent attorney, you have to be thoughtful. They're not your attorney, and it could be that they're trying to gather information that is not favorable to you. Okay? When they talk to you, be honest, be transparent, be helpful, be kind, but don't over expose yourself. Don't over explain. Don't get over involved with them. GALs, same thing. GALs can come across as wonderful people. They almost all are. They can come across as being on your side. They're not. They're only on the side of the child. That's why sometimes GALs will say, go get your own attorney. They're not telling you to do that. They're not giving you legal advice because they can't. But what they're saying is, I can't give you legal advice. Don't try and get the GAL to give you information on the sly. Okay? How about the therapist? The therapist is a therapist for the kid. Again, sometimes they will testify, and you have to be respectful and kind and work with them. But at the same time, remember, they're not someone there to gather information for you. CASA, same deal. I actually remember a case a while back where the attorney for the GAL for the case was a guy named B.J. Fett. And B.J. Fett was also a judge here in this town. And B.J. told one of our parents, Laura, that there's no way the child in her home was going home. She had a teen girl in her home named Sherry, and Sherry had a baby. And B.J. said, there's no way that Sherry's going to leave with that baby. You're going to adopt that baby. Well, that was music to Laura's ears because that's what she wanted. And she was hearing from everybody else in the case, including us, that that's not going to happen. Okay? But all of us tend to put our eggs in the basket that favors us. It's called confirmation bias. When someone confirms what you want to hear, you give them more credibility than other people. Let me say that again. Confirmation bias is when somebody tells you what you want to hear, and you agree with them, and you put more credibility in them because they're confirming what you want. So Laura put all of her eggs in that basket. That BJ Fett, who is an attorney and is also a judge in this town, was saying there's no way this kid's going home. We told her it wasn't going to happen. But she said it is because BJ said. So BJ said that if the county attorney doesn't make a motion for termination, he said, I will. And so the big day came. The county did not make a motion for termination of parental rights against Sherry and her child. And so BJ stood up in the courtroom and said, Your Honor, I'd like to make a motion for termination. The attorney stood there, and the judge, Teresa Cisneros, pulled down the glasses that she had on her forehead, and she looked at BJ and said, BJ, sit down. BJ sat back down, and that was the end of that. Foster parent was crushed. The moral of the story is the most important person for you to pay attention to is your home supervisor. And that's the last member of the group, your home supervisor. Your home supervisor is critical because they're the only one on the treatment team that has you as their primary interest. They're the only one advocating for you. They're the ones that have the information, okay? So it's critical for you to understand that those are the people that consist of a case. Let's walk through them again. Caseworker, casework supervisor, respondent attorney, GAL, therapist, CASA, birth parents, home supervisor, you. Then ultimately all these folks go in front of a judge. And we have to keep in mind all the different roles, and the most important thing for you to keep in mind is the only person that is advocating for you 100% is, who is it? The home supervisor. Okay? So keep that in mind every time that you get involved, and remember what I taught you about confirmation bias. It is not unusual for a foster parent to want something, to want so badly for this child to be adopted by them that they're not listening to the home supervisor, and they start shopping for opinions. And maybe one of the attorneys is against the opinion that the home supervisor is telling you. And so it's not unusual for you to say, I want to hear that person's opinion more. I want to side up with them. That is disastrous. Because again, attorneys are like coaches. They're going to cheer for something, but it may not happen. I've seen that happen over and over and over again. So again, keep this in mind. Remember the story about BJ Fett. The person that you want to work with first and foremost all the time is your home supervisor. Be kind, be open, be transparent, work with everybody else, but don't over divulge information. Don't get overly involved with other members of the case. Now, we've only got about a minute left, and I'm going to tell you something that's critically important. Your license is the most important thing you have as a foster parent. Your license makes it so that you can do this. Imagine if someone is a missionary going into Asia and they lose their visa. They can't get into Asia anymore. Then they can't be a missionary. If you lose your foster care license, we can't keep you. If the Department of Human Services doesn't want to work with you anymore, we can't keep you. There have been times when foster families got confused, they got involved with members of the treatment team, they splintered off from the whole treatment team, or maybe they took on the whole treatment team altogether because they didn't want to give up this child. And then what happens is the child moves on anyway, because we know as foster parents, we don't have any legal right to hold them away. Okay? The legal right belongs to the biological parent, and the custody belongs to the Department of Human Services. So when they insist that the child moves, the child moves. And if we make a big stink about it, if we fight with them about it, they may not ever place with you again. That's critical to understand. And if you lose your license, or if the Department of Human Services doesn't want to subcontract with you anymore, then we can't keep you at Hope at Home because there's nothing for you to do here. So these are the kind of the cold, hard facts of being on a treatment team and the importance of understanding the roles of each member of the treatment team and how you're going to engage with them. Now, should you be afraid of these people? No. I've known most of these people for the last 20 years. They're good folks, but they all have a different job. And if we don't understand those different jobs, it can be very confusing. Engage with them, enjoy the foster care process, but be clear as a bell about your responsibilities as a foster parent and how they differ from the responsibilities of the other members of the team. Welcome back. This is our third section of the legal process. In this section, we're going to be talking about intervening, becoming a party to the case. We're going to be talking about rules of evidence. And most importantly, we're going to be talking about keeping your foster care license. We ended the last section talking about how important it is for you to maintain your license. If you don't have a license, you can't be a foster parent. And let's go back in time a little bit and talk about how you get that license. As you recall, you came to Hope and Home, you filled out a letter of intent, you filled out an application, and we went through an exhaustive process with you called the Home Study, at the end of which you received an issue certificate form. The issue certificate form comes from the state of Colorado and is given to you through us. So the way that works is the state of Colorado licenses us and we license you with a 1-year temporary foster care license. And that license is contingent on a number of things. Those are the things that are in your contract with us. As long as you maintain that contract with us, and as long as you turn in all your paperwork and do all the things that you're supposed to do, you will maintain your license. If you lose your license, there's nothing that we can do to help you be a foster parent, because being a foster parent is contingent on having a foster parent license. Now let's talk about what happens next. Okay, what happens to maintain that license? What are the critical pieces? Critical piece number one, turn in your paperwork. Paperwork seems like it's not important. Paperwork is annoying. Paperwork is irritating. I have a very good friend who's a physician, and he says all of his life has been turned into paperwork. That's an exaggeration, but I understand what he's saying. He likes to treat patients. He hates to do paperwork, but that's where our world has gone. There's an old famous phrase that says, if you didn't write it down, it didn't happen. That's the way the court system looks at things. That's the way DHS looks at things. If you didn't write it down, it didn't happen. So they require you to go to doctor's appointments. If it's not written down in the file, they don't know that you went. They require you to get other appointments taken care of. They require you to see specialists sometimes. They require you to see a dentist. If you don't have it documented, they don't know it happened. The job of the state is to make sure you're doing your job. Our job is to help the state in making sure that the child is taken care of. Without documentation, we don't have it. I'm going to give you a couple of great examples. 2 cases that are very tragic and very difficult. The first one was the O'Donnells. Early in the morning, about 7 o'clock in the morning, I got a phone call from Rachel, the daughter in this case. And the daughter said to me, we have their child in the car, their foster child, who's 18 months old, and he's not breathing. He's turned white and he's not breathing, and they're racing to the emergency room. And this is the last phone call any of us ever wants to get, that there's a child dying in the back seat of a foster parent's car. They had woken up and this child was not breathing. This child was white, not breathing, and in the crib. They tried to get the child to breathe. They tried to administer first aid and CPR. They were not successful. They got in the car. They drove the child to the emergency room. I immediately went there, and we were able to do activate our emergency system here at Hope and Home, so everybody knew what to do. A group of us showed up at the hospital, and unfortunately we got there right when they took the child off life support, and the child died. Very, very painful moment. What made it even more difficult is in through the front door of the hospital came 4 police officers that were a member of the homicide department of Colorado Springs Police Department. So we have 4 homicide police showing up. Not regular police, homicide police. And they walked up and they talked with the family, the O'Donnells, said, we need your keys. And they explained that they had the right to take the keys. The O'Donnells wanted to say no, that's fine. They would require them to stay out of the house until they got a warrant, but either way, they were going in first. They went into the O'Donnells' house. They photographed everything, every room that they needed to photograph, and in particular the crib. They photographed every aspect of the crib. They took photographs of the med charts, every page. They took photographs of the doctor's orders. And again, probably 20, 30 photographs of the crib. DHS then got very much involved and wanted to look at all those documents because they're investigating what could be a homicide scene. They don't know. They're assuming the worst. And so they investigate it as if it were a homicide scene. They're also looking for what's called criminally negligent homicide, where the family may have done something irresponsible to cause the child's death. Were there things in the crib that weren't supposed to be? Critical question. In the crib was a wedge, so the child could sleep on its side. The good news is the family had seen a doctor the day before, and they had a doctor's order and specifically were required to have that wedge for the child. The child had lung issues. The child had a lung had a lung disease of some sort. I don't remember the name of the disease, but they had a lung problem with this child, and so they were on special medications. It was critical that the family had their CPR and it was up to date, which they did, and it was. Okay. Also, they went through every single page of the med log and the scripts that they got from the doctors. They were all accurate. In a moment like that, you don't have time to fill in your med log. And professionals know how to look at a med log and know if it's real. They know if you write 8 o'clock, 8 o'clock, 8 o'clock all the way across in the same pen, that you're doing it in a bogus way. They recognize that. And again, when a child is dying in your care, you don't have time to adjust that med log. Fortunately, everything was done right. They had their CPR and first aid, and they had everything that they needed to have on their documentation. It was all perfect, and there was nothing extra in that crib that shouldn't be in that crib. Be aware of this. Sometimes people say to themselves, well, my parents raised me with bumpers in the crib. No, you can't have bumpers in the crib. You can't have anything in that crib that's not considered safe sleep. And there are documents and information at Hope and Home that explain safe sleep. But this stuff is critical, and it's critical that you follow the Volume 7 rules, and it's critical that you document appropriately. Another family, the Wards, a wonderful family. I got a phone call in the middle of the day on a holiday weekend in the middle of the summer. It was either 4th of July, I think it was 4th of July. And Jeff called, I said, what are you doing? He says, I'm sitting here watching my house burn down. And it turned out this entire house burnt to the ground. I said, I'll be out there in a minute, Jeff. I got there right as it was getting done being burned, and the firefighters, one of which was a foster parent, Jesse, was putting out the fire. And it was amazing. Here was this house, and all that was left of it was this pit of just black soot. And it was amazing to see things like washing machines and dryers, huge chunks of metal just vaporized by this fire. Well, Patty tells the story that she put her son to bed, and she went in the backyard to put stuff on the line, and she saw what looked like a flicker. And she looked into Dustin's room, and there was a flicker. And she looked again. Yes, it was a fire. And so she walked over, she stopped putting clothes on the line, walked over, opened the sliding glass door, and the house was filling with smoke. She saw her child in a crib right next to her that they were adopting, and she saw over on the counter the fire extinguisher. She didn't know which one to go for. An impulse took over, and she grabbed the child, and she yelled to Dustin, "Fire! Fire!" And she ran out the front door. Dustin ran out the front door. As the door was closing, she heard an enormous explosion. The entire house exploded. And what we later learned from Jesse the firefighter was that when fires burn up very quickly, there's this whoosh of air that goes straight up, and that air caused every window at once to implode in an explosion inward. This was a matter of seconds from when she saw it, to when she got to the door, to when she grabbed her infant, to when she and Dustin were outside. Dustin initially had hid under the bed because he was afraid of the fire. Okay? By her yelling, "Fire drill, fire drill, fire drill," he knew where to go because he had done the fire drill over and over again. And he ran outside and he made it all the way down to the end of the driveway. Turned around, saw a fireball. I got there much later when the fire was being put out. Had they not done everything right, one of them would not have survived. They also had their fire drill and their log of the fire drill done. The very next day, DHS was in Hope and Home looking at the fire drill. And they wanted to make sure that they had done everything right. And unfortunately, everything was logged, everything was right, and the adoption of the infant took place 1 week later, even though they didn't have a place to live. They could have stopped that adoption if they felt that this family hadn't done everything right. Or more tragically, Dustin could have died underneath the bed, or she could not have gotten to the child in the crib. But they knew what to do, and they had the fire drill. Scary as can be to think that Dustin was initially hiding from the fire under the bed, and he would not have made it out if they hadn't practiced this over and over again. So things like fire drills, things like medication logs seem unimportant until something like this happens, and they're critically important. The other thing to realize is, as a foster parent, you're held to a high standard because you're taking care of someone else's child. And when you realize that, what you have to realize is that you could be held criminally negligent for their death if you weren't doing the things that you were supposed to do. If you weren't doing the fire logs. Maybe you were, but you just didn't fill them out. Or maybe you filled out in one night all at once, and it's clear that it was bogus. Those are things that can come back to haunt you. So I'm telling you, you have to make your paperwork count. You have to do it. You have to turn it in on time. And the state of Colorado is very rigid. We cannot relicense you. We cannot recertify you unless your paperwork is done. We've had a couple of cases recently where families let it go to the last minute, and we've had to have respite families standing by to take their children if they can't get it done by 12 o'clock midnight on the day it's due. Because we have to sign a perjury statement, and it's considered fraud if we say you have everything in and it's not. So paperwork is critical for a foster parent to maintain your license. Now, let's talk a little bit more about your license. Where it comes from Hope and Home, it gives you the ability to be a foster parent. In my mind, it's a little bit like your visa to go into another state. If anything happens to it, you can't be a foster parent. Also, if the county that you're working for doesn't want to work with you anymore, then you can't be a foster parent. And that's also critical. So let's go to the next thing. Let's talk about rules of evidence and how rules of evidence work, and then ultimately we'll talk about intervention status. Rules of evidence. In a courtroom, you cannot simply give the judge information. You can only give the judge information that is germane to the case. We've heard over and over about cases of rape where someone is charging rape and the other side, the defendant, wants to show her sexual history prior to the rape. Not admissible because it doesn't matter to this case. Lots of things are not admissible because they don't matter to the case. So a lot of times foster parents will want to stalk the bio family by going on Facebook and looking at things. They may see things that they want to bring into the courtroom and present. You can't because they're not germane to the case. In order to present something, it has to follow the rules of evidence. It has to follow the chain of evidence and make sure it's coming legitimately from where it's coming from. And so these are things that have to happen. I had a foster parent once tell a support group that they had written a 5-page letter to the judge, and it was all about how wonderful they're being to the child and how well they're treating the child. And then the judge ruled in their favor, terminated parental rights of the biological family, and the child then was scheduled for adoption by them, and they credited the 5-page letter they wrote. And then other people in the support group said, tell me about the 5-page letter. Give me a copy of it because I want to write a 5-page letter. And I had to interrupt the group and say, guys, the judge never read that. They said, how do you know? I said, because the judge doesn't want to be disbarred. It's a crime for the judge to have read that letter because it was not presented in evidence. And the reason for that is you have to do things in ways that are fair. Imagine if you're in court. Imagine if you are going through a divorce and your wife or your husband wants to secretly give a letter to the judge explaining all kinds of bad things about you. The judge can't accept that letter. First of all, because it may not have anything in it that is germane to the case. It may just be prejudicing, trying to create prejudice of the judge against the family. So you can't just present anything. Second of all, both sides have the right to see what it is and cross-examine and challenge it. So there's just no way that this 5-page letter went to the judge, and there's no way to communicate with a judge without going through the chain of command, without going through the rules of evidence, and that is through an actual attorney. Now, there is a provision in Colorado that allows a foster parent to be an intervener and become a party to the case. Why? Well, because in numerous cases across the country, foster parents have information that is critical to the needs of their children. We know these kids better than anybody else. You're going to know these kids better than anybody else, and there may be information that you need the judge to hear. Well, there are cases, most of them are back east, most of them are a while ago, where there wasn't a CASA, there wasn't a GAL, and the caseworker was overburdened with literally hundreds of cases, and kids languished. Kids' needs weren't being met, and yet the foster parent knew this. The foster parent had information that the judge could have ruled on and gotten the right services for the kids, but it didn't happen. Why didn't it happen? because they didn't have legal standing to speak to the judge. So the intervenor statutes were created so the foster parents who have knowledge about the children and can make this kind of information available to the judge are able to do so. So you as a foster parent may become an intervenor, and you may hire an attorney, and you may present evidence directly to the judge. But it's critical to understand this. It is specifically to give the judge information about the child. Now, I'm going to grab my phone here and open it up. I'm going to read you something that's critical, and this was in the case of AWR in 2006. At the PPH trial court, and the PPH is a preliminary protective hearing, the PPH trial court allowed foster parent direct testimony as to the child's physical, mental, and emotional conditions, but not on the issue of whether the child could be returned to the parent. You can only testify around the needs of the child, not around the issues of returning the child to the biological parents, because you don't have that expertise. You're coming in as an expert on the child, not an expert on the case, and not an expert on whether the child should be returned. So it's critical to know that a foster parent may become an intervenor. You may become a part of the case, but if you do so, a number of things happen. Let's talk about the consequences of what happened. First of all, you're not going to be able to provide testimony about whether the child should go home or not. They don't want to hear that. They know you love the child. They know you want to keep it. Being an intervenor does not help you keep the child. Second of all, because there's a caseworker that doesn't have a lot of cases, the cases here are less than 20 kids per case, so it's not a big overloaded system like back east. There is a GAL, there is a CASA, and you have a home supervisor. Because of all 5 of those opportunities to get your information to the case, the caseworker typically feels a little bit threatened when you do this and a little bit undermined. Now, the first thing that happens is the second you have an attorney, then your access to the OCA goes away. You can't work with the OCA anymore, and the case is now split. The OCA still represents the county, represents us, but not represents you. Also, as a party to the case, you're now subject to court orders. And we've had judges with some pretty outrageous court orders of the families that have become a party to the case. And finally, you're not able to actually give testimony about where you think the child should go. You're only allowed to testify in your area of expertise, and that is the needs of the child. Bottom line, we strongly discourage you from becoming an intervenor unless it's absolutely necessary, and there are very few cases where it's absolutely necessary. If you're interested in being an intervenor, you need to come in and talk to me and to Jackie Thurman. We'll go over all of the important aspects of what happens when you become an intervenor and what it's going to cost you. And we're not just talking about money. You can pretty much guarantee yourself that the moment you intervene in a case, that county will never work with you again. And that's some pretty hard medicine to swallow, but it's real. Imagine if you hire somebody, a subcontractor, to work on your house, maybe to finish your deck. And in the middle of that, they sue you. Are you going to hire them again? Probably not. The county has the right to have whoever they want as foster parents. They don't have to pick Hope and Home. They don't have to pick you. And like we talked about before, when you're in this room and you're the new person, all eyes are on you. They're excited about you. You can build your reputation and have have DHS wanting you. You can also do things that cause DHS to say, I want a parent for this child, but not those people. Don't be in that category. It's critical. There are times it might make sense to intervene, and we have good lawyers that we work with when that comes up, but you want to make sure you do it and you understand the cost financially and the cost in terms of what you're going to be giving up. But we also want you to be fully informed. So always come in and talk to Hope and Home before you jump into intervenor status. So this is Core 2, that's Section 3. We talked about intervention, we talked about the rules of evidence, and we talked most importantly about keeping your foster care license and paperwork. Welcome back. This is Core 2, Section 4, called 30-Day Notices. In this section, we're going to talk about what's called the 30-day notice, and we're also going to talk about some of the funding issues that go into foster care. Those are going to be our two main topics. What is a 30-day notice? A 30-day notice is when you give us the notice as required in your contract. You're required to give us 30 days when a child is in your home and you're saying this child can't be here any longer. Why do you give that notice? Well, there's a lot of different reasons, but let's begin with what is the expectation of a placement. The expectation of a placement is when a child is put in your home, unless you negotiate otherwise. We'll talk about that in a minute. When a child is put into your home, it is expected that you will keep that child until the case ends. And that means either the child is returned home, placed with a relative, or that child is adopted by you. So the expectation is when the child is placed in your home that they stay there to the end of the case. DHS hates it when kids have to move around a lot, and let's face it, it's not good for kids. So our goal is whenever a child is placed in your home, for that child to stay there until the case is over. Now there are exceptions to that. What's an exception? A negotiated length of stay. So this happens quite a bit, and it's fine. You get a phone call and we need to place a child on Friday, but you're going on vacation on Tuesday and there's just no way you can do it. So you say to Jess, who usually calls, and you say, Jess, listen, I'm not going to be here past Monday. Monday's my last day, and then we're heading on a vacation. And Jess says, well, if I can't find anybody else, would you be willing to do that? And you say yes. She can't find anybody else, so she calls you back and says, can you at least take these kids to Monday so we at least have a safe place for them to land, and we'll keep working on somewhere else for them to go. And you say, I can do that, but you got to be clear, I'm leaving on Tuesday. That's a negotiated case, and that's fine. If you say that up front, then that's what's going to happen. On the other hand, if you don't say that and you accept a case in general, and that's what most of our cases are, the expectation is that they're going to stay in your home until the case ends. Now, if you give your 30-day notice, you're allowed to do that. You're allowed to get out of this, and by contract, you're required to give 30 days. You'll tell us for a number of reasons, I can't do this, and I need to have the child removed, and I'm giving you 30 days. Then we negotiate that, or not negotiate that, we inform that to the county caseworker, and we work to get the child out in those 30 days. What are acceptable reasons for a 30-day notice? You're overwhelmed, you're exhausted, it's harming your marriage, it's harming your family, the children have needs that you can't meet. These are all legitimate reasons. What is not a legitimate reason? A family that says, look, we're mostly, and we don't usually say these out loud, but the message is we're shopping for kids. These kids aren't going to work. Let's return them and let's look for some others. That's a harsh way of saying it, but that's the message sometimes that we get when a family says, basically, I know I'm not going to adopt these kids, so I'm in this for adoption, so let's move them to somewhere else, and I'd like to start over with another group of kids. That is disaster. DHS will not place with you again if that's your reason for giving a 30-day notice. If you have health issues, we had a family one time where right after the placement happened, a severe case of shingles hit the mom. Well, we understand that. Those things happen. We've had cases where the kids were suddenly highly allergic to the dogs the foster parents have. Those things happen. So there are very legitimate reasons for a 30-day notice. But if you give a reason that doesn't make sense, and I'm not asking you to fabricate a good reason, I'm just saying be honest with us. But if your reason for having the kids move doesn't make sense, the Department of Human Services may not place with you again. Now, what if you need to have the child moved immediately? The case I mentioned earlier, where the child is allergic to the dogs in your home. What happens then? Well, we're going to try and get the kids out immediately. If there's an allergy issue, if there's some sort of issue like that, we're going to get the kids out immediately. If one time we had a kid that was in a cast and they couldn't navigate the steps. So there are legitimate reasons. One time we had a child that had such big medical issues, he couldn't climb the steps and get to the bedroom, which was on the second floor. All very good reasons to move quickly. We consider those emergencies and we move the kid as quick as possible. Now, It's critically important that you understand, please do not fabricate an emergency. Please do not have a child in your home and you really don't like them or you don't want them. You don't want to live up to your 30-day notice as required in the contract. So what you say is, I have an emergency. I could tell you some stories of emergencies that are actually kind of funny, but they're not funny to the Department of Human Services. So if they have to move a child, the entire treatment team gets upset about it. And again, they could say, I don't want to use that family anymore because they move kids too much. So that's what a 30-day notice is. That's an example of 30-day notices that are legit, some that are less than legit, and what an emergency removal is. Bottom line, DHS hates it when kids move around because it's not good for kids. And it upsets the judge, it upsets the CASA, it upsets everybody in there, and we try as hard as we can not to do it. If you have lots of kids removed, the odds are they're not going to want to place with you. And we talked in the last case, in the last section, about what happens if DHS can't place with you anymore. It doesn't make sense to be foster parent. So you got to think really carefully when you have kids in your home and you want them removed about giving your 30-day notice, and even more thoughtfully about asking them to be removed quicker than that. More importantly, if you're struggling, talk to us. That's why we're here. We're here to support you. Don't struggle and think, gosh, I don't want to bother the agency. I don't want to bug people at Hope and Home. I don't want to bother my home supervisor. And you let things that might be little blow up and become huge. Don't do that. Reach out to us. That's why we're here. We know foster parenting is hard. We know if you've never been a parent before, this is tough stuff. And even if you have been a seasoned parent, these situations are tough, and it's never easy parenting kids. So reach out to us before you get to the point where you feel like it's a crisis and now the kids have to be moved immediately. So that's 30-day notices. Let's move over to the funding issue of how is Hope and Home funded? How does this all work? One of the reasons you may have picked Hope and Home is that we are 100% scholarshiped. We don't charge anything when we license a family. We don't charge you anything. You pay your background checks, that goes to the background check people. You pay your CPR, goes to the CPR people. We don't get any of that money. And so when you come to Hope and Home, we're going to spend approximately $7,000 licensing you and about $2,500 to $3,500 a year maintaining that license. Why do we do that? Why do we spend that money, and where does it come from? It comes from donors who give to us because they believe in our mission. We have one large fundraiser every year called the Fashion Show. We're going to raise almost $1 million at that event. And we have donors who have been with us for over 20 years that give throughout the year. And that money, all of that money, is used to license and support foster parents. Because we get that money, we can give you a scholarship and bring you in. It does not mean that we treat that money lightly or frivolously. We have to be good stewards of the money that's given to us. And so it's really a big problem for us if we go through the process of licensing someone, spending the $7,000 it takes to get you fully licensed, and then you just kind of decide that you don't want to do it anymore. That's why we have commitment meetings. And in that commitment meeting, after your training is up, you're going to be asked to make a commitment. We're going to say to you, look, up until now, it hasn't cost us that much, and it hasn't been that much work for you. But after your training is over and before your home study begins, we're going to ask you in your commitment meeting to think thoughtfully about this. Is this something that you want to do, and do you feel committed to it? Because if you don't, you're going to waste your own time and, frankly, quite a bit of money of ours that could have gone to licensing somebody else. So we just ask you to be thoughtful about the money that comes to us that licenses you. We also want you to be thoughtful on the other end of this. Once you're licensed, we need you to be foster parents. We've had some folks that once they got licensed, they never ever actually took in children. I don't know why that happens, but it doesn't work. We need you to be able to jump in and work with kids and help other families with the challenges that they have. This is a critical thing to do, and it's important to us that you recognize that this doesn't happen for free. The money comes from our donors, it comes to us, and then we support you with it. And so it's critical to know as you're going through time with these kids and these families, it's on purpose. There's a very thoughtful process behind it. Hope and Home's mission is that we find families for kids in need. We do not find kids for families. This is an adoption agency where you pay us $75,000 and we go out looking for a child for you. This is an agency where we take in kids and then find families for them. And it's going to be through our foster family system. So it's important to understand this process because sometimes, again, foster parents didn't understand this and it leads to unrealistic expectations. We've had families come in here and think that we're going to be like an adoption agency and go looking for kids for them. We don't do that. We get kids presented to us by the Department of Human Services, and then we choose foster parents to support them. If a year goes by and you haven't done any foster care or respite, then we're probably not going to relicense you. If a year goes by and the Department of Human Services feels like you're butting heads with them constantly, we're probably not going to relicense you. If a year goes by and we can't get your paperwork in, we can't relicense you. So all of this stuff is critical because it leads to foster parents feeling frustrated, feeling like their expectations weren't met, and then leaving unhappy. We don't want you to do that. We want foster care to be an amazing journey for you and give you the incredible opportunity that we see all the time happening in this ministry. Now, we're going to end this segment a little bit early because I want you to watch an amazing video of a young lady named Rebecca. We often hear about the birth families, but we don't really get a feeling for who they are. Rebecca is a great example of a birth parent. What you'll see in most of our birth parents is they're not bad people, they're not scary people, they're not dangerous people, they're not people we need to be afraid of. Most of the time, they're sad people. Oftentimes, they were foster kids themselves. Rebecca is a great example of a birth mom and what happened to her, and an amazing ending to the story.
Hi, my name is Rebecca, and this is my story. My dad left my family when I was about 10 years old. I got into a lot of trouble. I started drinking and using drugs and doing what I wanted because my parents weren't around. So I ran away at 15 and I didn't tell nobody where I went. Being on the run wasn't all that great either. I then realized that this is not the way I wanted my life to be, and the best thing for me to do was to turn myself in. I was committed to Spring Creek, 0 to 14 months. I successfully completed all of that. Then I found out I was pregnant with my daughter, and she was like my miracle. She changed, just even being pregnant with her changed, the way I thought, the way I was eating, the way, just being healthy and providing for something new. And things were going really well for me, and I felt happy for the first time in my life. And my roommate, who I had roomed with, she moved out behind my back 2 days before rent was due. Everything kind of got overwhelming. I resorted to, partying and trying to substitute my pain with substances, and it led me to blacking out. I woke up in a hospital bed. I was covered in blood, and I had no idea what happened. I didn't know where I was. I didn't know where my daughter was. Social worker talked to me in the hospital and told me that they were gonna come see me. When I got home, it was horrible. There was blood everywhere, and my glass tables were broken. It broke everything. I don't know why. And a couple weeks later, they were knocking at my door, and they took my daughter from me.
Our first placement was Callie Mae, and we did get her on December 23rd. We picked her up at a park and ride there off Woodman and I-25, and she was asleep, just 7 months old, cute little baby.
Callie had a diaper bag in her car seat, and she was sleeping when we got her, and pretty much the whole ride home slept. And when we got home, she kind of opened her eyes, and
we just loved on her instantly. You know, we could tell pretty quickly that she came from a home that, you know, she saw love, she was well cared for. And Leslie and I remember mentioning to Leslie, you know, this is a baby that's loved and is taken care of. Let's not get too attached here. So, you know, there's all these emotions where, you know, we're laughing, we're taking photographs, we're having a great time, you know, but in the same token, we're wondering, what about her mama? And what is she feeling right now? So pretty instantly, you know, our love for Callie Mae bled over into Rebecca.
Callie had 3 visits a week with Rebecca, and so through the course of time, just got to start to know Rebecca, and as time went on, just fell in love with Rebecca. I felt like I could be her mom as well as Callie's, and just developed a real love for her, and developed a real close relationship with her. And it was an amazing process to watch her growth as she was working to get her little girl back, and I knew she loved her little girl very much. And the more I heard about Rebecca's story, the more I realized that she had come upon some really difficult times in her life, and all at once, and she's young, and she doesn't have a real great support system, or didn't at the time, and she, I think, kind of felt all alone and kind of felt hopeless.
I remember the first day walking into Hope and Home, and there was a bunch of smiling faces and a lot of friendly people. It felt good to have people that cared, you know. They were just loving people in general and cared about everybody.
I told Rebecca, I said, Rebecca, I want to be your partner here to help you get your little girl back. I'm not trying to be her mom, but I'm going to take care of her while you get the help that you need to get. We had Callie until June 17th, and then she returned to Rebecca. And I'm not going to lie and say, gosh, that was a piece of cake, no problem. It was hard. You grow attached emotionally, especially with babies.
You know, there is a special place in our heart for Callie. We're so excited the fact that Rebecca has been able to do exceptionally well, and she really found a lot of strength in and of herself to just pull together and fight for her kid.
I had never wanted anything so much before, and not only did I get my daughter back, but I got a new family too.
It's been a real blessing in our life to be able to develop a relationship with Rebecca and continue to share in her journey too, and still be there for her and be there for each other.
Welcome back. This is Core 2, Section 5, and before we start our class on the legal steps leading to foster care, let's take a moment and talk about the Rebecca video. My guess is it's a little bit surprising. My guess is most times when we think about the birth families, we think of scary people. We think of bad people, people that hurt kids, people that abandon kids. Honestly, they're most like Rebecca. Most of the birth families I have known are a lot like Rebecca. They're not mad, they're not angry people, they're sad people who have been the victim of a lot of circumstances. Rebecca came into this situation because of her life and where she's been, and her child was real important to her. What's great about this story is how the family partnered with her, connected with her, and really how Hope and Home as a whole wrapped around Rebecca and cheered her on and helped her get back and get Callie back into her home. This foster family actually became almost an adoptive family of Rebecca and her child. Great story of reunification, and a good example that not all good stories end in adoption. Many great stories of foster care end in reunification, where the families are connected and oftentimes stay connected for the period of the life of the family and the kids. I've had foster families who have connected with the biological families in this way, like with Callie and with Rebecca, and have stayed connected throughout their lives. And that is an amazing testimony to the power of the Holy Spirit. Foster care is about reunification, restarts, new starts, reunification, new starts, and believing in people, believing that through the power of the Holy Spirit, drug abuse can be overcome, that parents who have had bad things happen to them can break the cycle and not do bad things to their kids. So I want you to be open when you think about foster care. It's not all about adoption. Great stories of reunification like Rebecca's happen a lot, and they're wonderful to be part of. Okay, let's go on to the legal steps that happen when a child goes into care and how they go through the legal system. We have a handout here. It looks a little bit like this, and we're going to pull it up on the screen and we're going to talk to it. So let's go ahead and do that. We're going to pull this up. Now, as you're looking at this, it looks like a whole bunch of arrows and boxes, and it is, but we're going to walk through each of these sections so you understand how a very complicated process happens. We're going to begin at the top where it says a call comes into 1-844-CO for kids. This is the statewide hotline. That hotline takes all of the emergency phone calls in the state of Colorado, then sends them to the local county. So that phone call comes into that number. Somebody is reporting abuse or neglect. Then it gets sent to the local county, and every single morning, every county has a RED team that meets. And RED stands for Review, Evaluate, and Direct. The RED team will evaluate in El Paso County as many as 50 kids in a single morning. Think about that. In El Paso County, there are approximately 16,000 of these crisis calls a month. 16,000 per year. I can't imagine if they were per month. But 16,000 a year are huge. That's a huge number. If it was 12,000, it would be 1,000 every month. So let's think about that. Over 1,000 a month come in. That's over 250 a week, and that's over 50 a day. So this RED team has to sit down and read through all of these reports, and they have to make a decision. Do we screen them in, or do we screen them out? About half of the ones that come in are screened out. It means that there just isn't enough information to go on. Maybe we don't have all of the information, or maybe it's just kind of nitpicky. Somebody doesn't like somebody or something like that. It has to be actual abuse or neglect to be screened in. Once it's screened in, there are 3 categories it can go into: low, moderate, and significant. If it's a low situation, it means that there are no safety concerns and the risk is low. And they have to see that kid and evaluate them within 5 working days. If it's moderate, well, we have some safety concerns, and we think the risk is moderate. So we need to do it in 72 hours. Or immediate, and that's significant. If it's significant, or what we call immediate, it means there are safety concerns and the risk is imminent. And in that case, the worker goes out that moment and sees what's going on. These happen in RED teams, but they can also happen even over the weekend or late at night. If there's an emergency, the team will go out on call and see the kid immediately. So in an immediate situation, they're making the determination that the child is at imminent risk or has been harmed. Okay, once they get out there, once CPS, Child Protective Services, goes out, they perform a assessment. And when they're doing that, we see the stuff on the side here that says they're meeting with everybody. They're meeting with the child, usually alone, because they want to hear what the child has to say. And they meet with what are called collateral contacts. They're meeting with siblings, parents, and other people, teachers. They're trying to get some information here. Now, when they're doing this, they have some options. On the far right, you see that they can find some services in the child welfare community, and they can do community-based services, things that can help them. It might be something as simple as the family is struggling financially and they need food stamps. So there are different kinds of things that they can do. Well, once they've made their assessment, it goes down in 2 arrows, and you can see where that goes. The green is there's just not enough evidence of abuse or neglected, so it becomes unsubstantiated or unfounded. There are only 3 categories: founded, unfounded, or unsubstantiated. So if they can't substantiate it or they don't think it happened, it goes to the right there on the flow chart to the green box. And at that point in time, they have a number of options of things they can do. They can close the assessment, or they can refer the family for non-court involved services. Now, on the left, we see the bright red where the explanation point is in the yellow triangle. And that says there is evidence of abuse or neglect, and it's substantiated, or what we call founded. When it's founded, then we have some options. As we go down, we can either take a right turn there and say, yeah, that's founded, but it's not a high risk situation. There's low risk or no risk of it happening again. And so if we think that there's not a high risk of this happening again, we can close the assessment, or the family can also be referred for non-court involved services. But if the person doing the investigation concludes that the child's been harmed, or they're at imminent risk of future abuse or neglect, or there's ongoing concerns, then they have to do something different. In that case, a court case is opened, and they contact a judge. And in that situation, the child is removed. Now we have a couple of options here. The child can be placed in out-of-home care. Out-of-home care can be a relative, a friend, or foster care. Or they can stay in the home, but significant services are added. Sometimes, for example, if they're with a mom and a dad, they move them with relatives, and the mom and dad go as well and stay with those relatives. So there's a number of options they have, but the bottom line is they can either put supports into the family where the child has been abused or neglected, or they can pull the child out of that family and put with relatives, friends, or foster homes. Now, if there is a determination to open a case, the intake caseworker must consult with their supervisor. The supervisor grants permission, and the caseworker then calls the county attorney for permission to call the judge. The county attorney, remember we talked about the OCA, the Office of the County Attorney? That's who we're talking about here. The county attorney has to make the determination that there is a legal basis to support intervening with either protective supervision, where they're supervising the child, like I said, and they have some supports in place, or that where the children stay in the home, but the parent might be ordered out of the home. Or they can make a decision to move the children in with kinship, kin-like placements, or in foster care. If no appropriate relatives are found, they then give that caseworker the authority to place the children in foster care. So let's run through that again. A foster parent is contacted only after this whole sequence of things occurs. There has to be a determination to open a case. The intake caseworker must consult with their supervisor. The supervisor has to grant them the authority to call the OCA. The Office of the County Attorney has to give permission to contact the judge. The OCA must decide that there is a legal basis that would support intervening with either protective supervision, for example, the kid staying in the home but the parent being ordered out, or they make a decision to move to a relative or kin. If no kin is available or appropriate, then they can make the decision to place with a foster home. The caseworker then must present the case to the judge, who will authorize verbal orders. And a lot of times this happens in the middle of the night. And those verbal orders are good until a 72-hour preliminary protective proceeding can be scheduled. That's a PPP hearing. So that PPP hearing happens within 72 hours of the verbal order given by the judge. During this time, the parents are usually allowed one visit and that's one visit within 7 days, and a team decision meeting is held. And this TDM, or otherwise known as team decision making meetings, are held with the family with the goal of specifically discussing the placement of the child. The participants are the ones that the family feels comfortable with, and that's usually their attorney, their friends, their family. In those hearings, we sometimes are present to learn more about what's going on, meaning either you, the foster parent, or we're present, but not always. And there's always, if we are present, there's always going to be a section of time where they ask us to step out of the room and they discuss confidential stuff with the biological parents. Now, I know that's a whole mouthful of stuff that happens, but when we're looking at our flow chart, that's what happens to get that child in that one little box where it says child is placed out of home, where it says open court case, and then it goes to child is placed out of home. All those things I just described just happened. And if they have to happen at 2 o'clock in the morning, they happen at 2 o'clock in the morning. Now you see it drops down into the dependency and neglect court process. Each one of these cases is what we call a DNN, okay? And DNN stands for dependency and neglect. That means the family is the ones that have a child. The child is dependent upon them, and they are neglectful. The court has to make both those cases. It has to say that the family is the one that the child is dependent on, and they must conclude that neglect or abuse occurred. So as we take a look here, the very first thing happens within 72 hours is the temporary custody hearing. Has to happen pretty quick, has to happen within 3 days to decide who gets custody. Then there's an adjudication hearing, and usually the dispositional hearing occurs at the same time. And these are making the decision that the child does need to be in foster care. Now, let's go back in time a little bit where we talked about them coming up with the plan for the parent. Remember we talked about that? We talked about how there's an FSP, a family service plan. This is where the family service plan is introduced, and this is where the family service plan gets its stamp of approval. Both lawyers, the OCA and the foster parents, the OCA who represents the foster parent, and the respondent parent attorney both have to agree to this. Oh, that was a mouthful. But they both have to agree to it, and it has to be signed off on by the judge. And at that point, we start moving forward. Now you see the next thing we have are review hearings. Review hearings happen every 30 days to make sure that two things are going on. One, the child needs to remain in foster care, and two, the active efforts are being made. You will see if you go to court at a review hearing, the two motions that are always made by the OCA. One is the child remains in foster care because it needs to, and here's the reason why. Here's the evidence that supports that. And two, that reasonable efforts are being made to move forward. Oftentimes, the parent's attorney will argue, the respondent attorney will argue that either one of those. They'll say that we don't think foster care is necessary and why. And they can argue that reasonable efforts aren't being made. But most of the time, people have signed that FSP, so we're moving forward and we're trying to make this all work. Then eventually we have a permanency hearing. We have those every 6 months where we review the permanency and the permanency plan. If we need to make changes in the permanency plan, we will. This is a very tricky time for foster parents because foster parents unfortunately get sucked into the case and oftentimes think that they understand what's going on. And this is tricky because stuff isn't always as it appears. So for example, every 6 months they can change the permanency plan. That's on the document where it says what the permanency plan is. It does not mean that is what's going on in the head of the caseworker. It means they're following the rules that are set forth by the system. They're doing what they're told to do. So it is oftentimes the case that in the back of their head they're thinking, I really don't think this is going to work. I really got to have plan B, C, D, and E in place. But they're still showing that as the permanency goal because they're still trying to make it happen. So when you look at the permanency goal, don't get all freaked out that your name isn't there or it doesn't get changed. That means very little because we don't know what's going on in the heads of the caseworker at this time. this is the process. Once we get to that point, the courts have approximately 1 year to figure out where this kid is going. Going home, going with a relative, going with kin, going with a kin-like person, or adoption by a foster parent. It takes about a year. Now, it can take longer than that. It can take 2 years, and sometimes I've seen it take 3 years. Once a decision is made, if the foster parent is chosen to be the person that the child is going to, they either have to terminate parental rights, or oftentimes they go through mediation with the biological parent, and they do something called confess the motion and agree to terminate parental rights. This is important. The better your relationship is with the biological parent, the more likely they are to confess the motion and give you basically their child. If they hate you at this point, if you guys have fought at this point, if you're seen as there's a lot of animosity seen, if you're seen as being oppositional to them, frustrating them, challenging them, if you're not nice to them, then they're oftentimes refusing to do that. They're refusing to confess the motion. So it's critical to know that if you get to the end of a case and you have formed a good relationship with the biological parents, the odds, if they need to confess the motion, is that they will. We've had parents digging their heels just because they don't like the foster parents, and that's a no-no. To the degree that you can, your goal is always to form a strong alliance with the biological parents, and it pays off. I have seen cases where the children have been returned home. I've seen many cases where the children were returned home, it didn't work, and the biological parents have their children removed again, and they say, you know what, I'm going to be okay with it this time. I'm not going to try anymore, and I'll do that as long as they go back to the foster parents I had before, because I liked them so much. The kids called them mom and dad. Okay? So if we understand that, it's critically important to be involved with the biological parents and have a relationship with them, because all the way down to the end, they have still parental rights, and they still have the ability to either fight or to confess the motion when we get to the point of termination of parental rights. After the termination of parental rights happens, then we kick your case over to the adoption unit, and we're going to talk about that in our next section. Okay, we're back. This is Core 2, Section 6, and we're going to be talking about adoption. I hope you're holding in there. I realize this is 6 tough sections. It's very dry, it's very legalistic, but as I said in the very beginning, the number one reason foster parents quit and are disheartened is because they have unrealistic expectations, and a lot of times those unrealistic expectations are about the legal process. So I hope this is helpful, laying out the legal process, how it works, what legal standing we have, what legal standing we don't have, and how to navigate the system. So let's move forward. This section is on adoption. We ended on the last section talking about the legal steps that go through to adoption, and we quit right when we got to the point of adoption. So at the end of all of the stuff we talked about last time is the chance to adopt a child. The child is now legally free and available for adoption, and the county caseworker has selected you as the person to adopt this child. I want to begin by, I feel bad because I keep bringing up things that are challenging, but I don't want you to have any surprises. So at this point in time, you think to yourself, wow, we're done. We've been through all this stuff. It may be a year or several years, and we're finally at the point of adoption. Here's the final warning. Until that gavel hits the judge's desk, we're not there. Okay? Until that moment happens, it's not done. Okay? And so we have to be always thoughtful of that. Don't get your hopes up beyond realistic expectations, because until that gavel comes down, it's not done. A foster parent I care very much about, Amber, wonderful foster parent, was all set to adopt Luke. Luke was a baby that had been in her home for a long time, and we were at this point. Termination of parental rights had occurred. There was no other option for this child. There was no other relatives. There were no kin. There were no kin-like people that could be approved by the home study process. No one qualified that she came up with, and nobody else was out there. And so it was finally time for Amber to adopt Luke. In the very last seconds, the biological mom coughed up the real name of the real dad. And until this point, we didn't know who that was. So she told the Department of Human Services, here's the name of the dad. Up until this time, she had been dishonest about who the father was. So that caused the case to be continued. Now, as we said earlier, under expedited permanency planning guidelines, permanency has to be found within a year or good reason given why it wasn't. Well, this is good reason. At the last second, there is a person out there who, through no fault of his own, didn't even know the child existed, much less had the opportunity to be that child's father. So they went and they contacted the guy who was, as you can imagine, quite surprised. They did a DNA test, and lo and behold, he was the father. So then he was given a chance to see if he could take this child. So they did a home study on him, and lo and behold, there was nothing wrong with him. There was no reason why he couldn't take this child. So in the last few minutes, right before adoption, that happened, and Amber had a deal with Luke going to this other person. And I want to give a shout out to Amber in this situation, because while she was crushed, devastated that this was happening, she made a very powerful decision, and that was not to take it out on this dad. What did he have to blame? What did he do wrong? Nothing. So Amber connected with this guy, and it was amazing because they became friends, and ultimately Amber became the godmother of this child and is still involved in this child's world to this day. So again, another story about how important it is to connect with the biological parents, and don't count your chickens until they're hatched, in this case, until the gavel comes down. Are there other situations where you could get right up to the edge and then not be able to do it? Unfortunately, there are. And I'm going to tell you a couple of quick stories and give you a warning about something. And it's very important that you hear this part. We do a home study before you ever get out of the stall. Before the race even begins, you have to go through a home study process. That's just the first home study. There's a second one. And a lot of people don't realize this, and this information can be devastating if you don't understand what I'm about to tell you. We do a home study, and in that home study, we assess that you would be a good, suitable parent for these children that you're going to have placed with you. Once we get all the way through parental rights being terminated, at that point, your case gets kicked over to the adoption unit, and an adoption worker does their own home study. And that's because the county has to, but it's also because they want to correlate the information with what we gave them in the beginning. Are you really the same person that we told them about? They read your home study in the beginning. Now they're going to compare it to the home study that they do. If they don't correlate, now obviously things have changed over the years, if it's been a couple of years, but if in very important ways, if they don't correlate, they can, and they have, stopped the adoption. I'll give you two examples of that. We had a foster parent here at Hope at Home who we really liked a lot. She did a really good job, but secretly, she was a closet screamer. I don't mean that she screams in the closet. What I mean is that no one knew it, but she dominated her family by screaming at the kids. Everyone was afraid of her. Husband, kids, everybody. And her screaming was intense, and she yelled at the kids all the time. When she was confronted on this, she said, well, some people eat too much, some people smoke, I scream. How much? How often? What's the impact of the kids? What's the severity? What's the intensity? What's the frequency? All these questions came up in the home study that was being done by an adoption worker. She was so concerned, she ordered a family interactional study where a therapist watches the interactions of parents and children, and found that the screaming was so significant that it impacted the bonding of the kids with the mom. How did she find this out? Well, because there's a series of questions they always ask kids. Now keep in mind, the caseworker is going to visit your home every other month. There's a couple questions they always ask. The second question they always ask kids is, what happens when you are bad? What kind of things happen when you are in trouble? And that's how they get to what kind of discipline goes on. In this case, the little girl said, When I get in trouble, my mom screams at me and I'm afraid. And I can never do anything right. That was a trigger for the adoption caseworker to look into this case and say something more is going on. Her home study was significantly different than ours and pointed out significant problems within the family systems about dealing with mom in particular and her yelling. They put the adoption on hold. The family had already scheduled it. Airplane tickets had been booked. A place to celebrate the adoption had already been booked. And they were devastated. And they went and they dove into this. They analyzed it. They had therapists look at it, and they came to a conclusion that unless you get a handle on your anger, we can't place these kids with you. They moved the home study, or excuse me, the adoption back, and they finally said we're going to postpone it indefinitely until you go through therapy and we were able to have a belief that you can take care of these kids. They chose not to do that. The kids were removed. These kids were 2 and 3 years old and been in the home almost their entire lives. They were moved to another family who adopted them within the next 6 months. Your home study is critical. It must match up with your second home study. I mentioned that there's 2 questions that people always ask kids, and the second one is, what happens when you're in trouble? The first one is, what did your parents tell you not to tell us? Okay, so, and kids always tell. Art Linkletter proved that. Kids always tell. If you remember the Art Linkletter show, we'd always ask kids when they came on, what did your parents tell you not to talk about on the show? And the kids would tell. Kids always tell there are no secrets. So it's critical that you be transparent and that you live the life that you described to us in the initial home study. You cannot try and trick the home study. You cannot tell everybody the right answers in the home study and live a different life with either discipline or drugs or alcohol or with domestic violence. These are all things that come out. So it's critically important that you live realistically with us. If there are issues going on in your life, talk to us about them. Don't hide them. No one's perfect. No family's perfect. We don't expect you to be. But it's critical that your home study in the beginning matches on the key areas, the values, principles, and way that you parent the kids at the end. Okay, so that's the second way in which we can get to the end of a process. We have had several, not a lot, but several parents get to the end of the process and not be able to adopt the children in their care because the home study was different in one case, and in the other case, we had other significant things going on at the very end, and the home study discovered that. So there are 2 reasons why we could get to the end of the case. Parental rights have been terminated and we don't get to adoption. One is if someone shows up unexpectedly at the end, like what happened in Amber's case, or in our second case study, if the home study doesn't match up with the initial home study. Okay, let's assume we get past that. Neither one of those conditions happens to you and you're in the process of going through the adoption. At that point, you go to the courthouse and we actually have the adoption. Hope and Home is available to you for the adoption party afterwards, or you can certainly go anywhere you want. My recommendation, make this a big day. Every child remembers the day they got adopted. My recommendation is celebrate it, make it fun, make it a big deal. Invite everybody you can to the courtroom. David Lewis did an amazing thing. He asked for the court's permission to do a prayer right there in the courthouse, and it was amazing. This is your day. Take advantage of it. Enjoy it, celebrate it, make it a big deal, dress up, bring everybody. The judges love Adoption Day. Why? Because everything else they do is kind of painful in one way or another. Somebody wins and somebody loses. On Adoption Day, everybody wins. So I can't emphasize enough, have fun with it, celebrate it, enjoy it. Now, once the adoption's over, what does that mean? Well, first of all, it's forever. They will tell you during the adoption process that this child is now yours as if born from you. They can inherit through you. They are your child. Every once in a while, I hear somebody, not a Hope and Home family, but I hear families talk about relinquishing their children. You cannot relinquish. There is no concept of relinquishment in adoption. Once the child is yours, they're yours 100%. If you choose to do something called relinquishment, what you're really doing is just giving your children back to the state, and you now become a birth parent, and that whole list that we just went through now applies to you. Okay? You become the subject of DNN. So you have to understand this is permanent, this is real. They are yours as if they were born from you, and they will inherit and live through you. So that's critical to understand. It's wonderful. It means that you will never write an incident report again. You no longer have to fill out all the paperwork for Hope and Home. I had a foster parent once tell me on the way to the adoption that her child fell and skinned her knee, and for the first time she doesn't have to fill out an incident report. So that was adorable, and she got to the courtroom and she was fully adopted with the Band-Aid on her knee and everything. Now, once they're yours, there's some important things to think about, okay? Whether they were adopted in the middle of their life or the beginning, or if they were adopted at 13, 15, 12, or even 1 day old, kids who have been adopted always have a urge, a drive to find out where they were from, to meet their adoptive parents. This is not wrong. It is not unusual. It is no insult to you. They're not being disrespectful to you. They're not being unloving to you. But when kids grow up, they want to know where they're from. And our ability to help them know that they're adopted, know the story of their adoption, and know that we love them and support them even when they want to go and find out who their adoptive parents are. We've had a number of kids want to do that, and our foster families sometimes feel insulted or they feel hurt. Don't. This is normal. It's normal for them to want to do this. Most of the time they go meet the parents. Oftentimes they have had fantasies of who their parents were, that they forget the bad things and only think of the good things. They meet their parents and it's mostly like, the story I tell is you can lie in your bed late at night and you can see this huge monster on the wall, and you're terrified of it, and you go turn the light on. It's just a coat rack and its reflection. That's usually what happens when biological kids meet biological parents. It's no big, awful, terrible person. It's no wonderful person. It's just a coat rack. It's just a regular person, and they remember why they got into foster care in the first place, and they remember how great it is to have, and they realize how great it is to have you as their parents. So don't be threatened by this. It is a normal thing that happens when children are adopted. Now, how about some of the logistics? Well, if the child is over 5 years old, they are usually eligible for an adoption subsidy. Talk to your home supervisor about this. Any child adopted out of foster care qualifies under the IRS as a special needs child, and there is a tax credit of about $12,000 that you get per child. We had a family that adopted 5 kids. They got $60,000, made a huge difference in their ability to move into a home that would hold 5 kids. Also, every kid that comes out of foster care gets Medicaid until they're 18 years old. These are all important things. If the child is adopted after age 15, they also are eligible for tuition payments through the FAFSA system. So they can apply for financial aid and get a Pell Grant, and most of them go to college for free. Most important thing, at the end of the day, they're adopted, you have a family, and it's time to be a family and move on. Last year we had 33 adoptions. This year we're expecting to have more than 50 adoptions. And that means that you are not at the end of the process, but really you're at the beginning of the most wonderful process in the world, and that is being a family. And I just want to close with my favorite scripture of all time, and that comes out of Jeremiah 29:11. For I know the plans I have for you, declares the Lord, plans to prosper you and not to harm you, plans to give you hope and a future. God bless. Now, we're at the end of our time. At this point, we don't have discussion questions. What we have is a short quiz. Please take the quiz and return it to your licensing specialist. And again, God bless.